Welcome back to Canon Law in Exile, broadcasting to you from Dunniganshire Studios. And today we're going to talk about the Dallas Charter and the Dallas Essential Norms and some of the critics of the penal law in this area, the area of accusations against priests and deacons of abuse of minors. So, in our previous lecture, number 5, that was on SST, the kind of new penal law since 2001. And before that, the code itself on particular crimes. That was 4. So now we're completing it. I hope we'll be able to do it in just this one lecture. We're doing essentially the particular law of the United States. So, a word about that. So today we're talking about the Dallas Charter and the Dallas Essential Norms. Now, the Charter is probably the most famous document. It's often quoted. It contains the so-called one-strike policy, which we'll talk about, but it's the Dallas Essential Norms, sometimes just referred to as EN. Those are particular law for the United States, the Essential Norms. Now, in your own diocese, if you're in a U.S. diocese, your bishop or your diocese will have enacted its own version of the Dallas norms. So you'll want to be familiar with those, not really for part of our class and not necessarily for writing your opinion letter / thought piece, but it's just a good idea to know what's in your own diocese's policy. If you want to discuss that in your opinion letter, that's fine. It's not really a part of the assignment, but it would be a fine thing to do. Whether you do or not, though, you really want to have a copy of your diocese's own policies on this matter. They're almost all on the diocesan website, so you should have no trouble finding them. Okay, first question I want to ask you about the Charter and Essential Norms, so I hope that you've had a chance to read those. They're not too long, so it shouldn't take long to read, but then also to read the criticisms by Father John Coughlin. He's a Franciscan priest and a civil lawyer and canon lawyer who teaches at Notre Dame, very well respected. And then Cardinal Avery Dulles, who's passed away now, but also had a tremendous career, lived to a very old age, and wrote a number of books on a number of subjects. So, extremely respected voice. And then also the Sarah MacDonald article about the priest from Ireland who was wrongly accused. Those are essentially our readings for this lecture. Okay. One thing to think about in the Dallas Charter is how prominent are the rights of the accused. That's one of our concerns. That's not the only concern of your thought piece, but it's kind of the key concern. It's the major concern. I think if you were going to give a fair reading of the Charter, you would have to say that yes, it does address the rights of the accused, but no, it is not a major theme. To me, that's the fairest reading. See how it strikes you, but so just kind of keep that in mind. Another thing you'll have to keep in mind is that the Dallas norms and Charter, they were revised from their original form. Their original form was in 2002, and they were revised one or two more times in the following years. And I'll mention that, especially when we talk about the Dulles article, because it's going to make a difference there with some of Dulles's critiques. But what the charter and the norms both are most famous for is the so-called one-strike policy. If you're not a baseball fan, have somebody explain baseball to you. And basically, though, the one-strike policy is that if there is even one instance of abuse of a minor, then that priest or deacon is to be taken out of ministry permanently. Now, you've probably all heard of that. It's so you're probably not too surprised to have that come up. But there was an interesting question really 3 weeks ago in one of our last classes. Mr. Trainer asked a question, and he said, that actually this was after class, so probably not many of you heard it, but he asked, is it conceivable today that someone might commit an act of sexual abuse, again, a priest or a deacon might commit an act, and not be deprived of the clerical state? Remember, the penalty provided in Canon 1395 just says a just penalty, and deprivation of the clerical state is the really probably the most severe of the penalties, but it's become quite common. So Mr. Trainer asks, is it at all possible that someone might have committed an act of abuse and would not be reduced to or returned to the lay state? A really interesting question. I think I'd say for the most part, probably not any longer. Probably now, at least if it's sure that this incident actually did occur, it's probably very likely that the priest or deacon would be returned to the lay state. However, keep in mind, or put in your mind if you don't remember this, when these norms were first enacted in 2002, the Dallas one-strike policy actually was somewhat controversial. And for instance, Cardinal George raised this concern. He said, what if there were a priest who was ordained, say, in the 1950s or 1960s, and when he was recently ordained, so still in his 20s, he had a brief sexual relationship with a 17-year-old female, but never committed any other offenses, served for decades in ministry without incident. Should he be removed permanently? And so that was the clear implication of the question on Cardinal George's part was probably not. Probably he should not, if it truly were the only incident and it was decades ago, probably he should not be removed. And Rome seemed to be of that mind as well. In 2002 and 2003, we really forget this because Rome has essentially approved what the U.S. bishops recently have done. But Rome was quite initially, at least many voices in Rome. It's always hard to... We've talked about the difficulty with saying Rome says or this is Rome's opinion. But you would hear respected voices being very critical in this 2002, 2003, probably into 2004 period, and maybe even a little bit later, thinking that the U.S. bishops had gone too far. Remember, the Dallas norms, the original version was debated, drafted, and enacted all within 2 days. That was part of the circumstance that made people think that maybe insufficient thought had gone into them. Why did that happen so quickly? Because there was an explosion of revelations about several just shocking cases of abuse in the U.S., primarily Boston, but also Los Angeles, many other places too, but Boston was probably the main epicenter, and Los Angeles really not too far behind. So again, these kind of criticisms of the one strike policy, we almost forget that they ever existed because uh, we haven't we haven't heard many criticisms of the one strike policy uh, recently, but but they at least were there early on. Also, probably again in further response to Mr. Trainer's question, is it possible that that there could be an actual quite likely incident of abuse that would not be punished by return to the lay state? Probably right now, the only time you would see that is if the cleric were quite elderly and or sick. You may remember in 2009, I think it was, this is what happened to the founder of the Legion of Christ, Marcial Maciel. He uh, was essentially placed in a life of prayer and penance. That was sort of his. That's kind of the fallback if the priest is aged or if he is quite ill. Then instead of being removed from the clerical state, then he will be uh, required to assume a life of prayer and penance. Okay, one of our critics, Father Coughlin, writing in 2003, kind of asks a similar question as Cardinal George. He raises a very similar situation of kind of an infraction with a 17-year-old female. Should this automatically result in return to the lay state? And one of the things he says is that traditionally canon law has uh, taken proportionality into account and has said that this is something that should be considered. And again, I think it's fair to say that at least writing in 2003, it seemed pretty clear that it was Father Coughlin's implication that perhaps not every case, again, if it were a single incident decades ago, not every case merited permanent dismissal from the clerical state. You remember when we first started studying penal law, we studied several factors that prevent penalties from coming into play and some that require the mitigation of penalties. Those were in canons 1323 and 1324. And in some ways, those canons in many ways were about proportionality. And Coughlin is saying, proportionality, flexibility, discretion, having the penalty track the crime, those are very important in canon law. And I'm not totally sure. He seems to be saying that the Dallas Charter and norms are really true to that tradition. Okay. Why did we get the one strike policy? Some very interesting quotations from both Coughlin and Dulles. And really what they say, and I do not think too many people would disagree with this, they say the bishops did such a bad job in responding to complaints about abuse in the decades leading up to 2002 that they enacted this one strike policy almost to insulate themselves from even having to make decisions in the future. So Dulles, now this is an article that Cardinal Dulles wrote in 2004. He says, having been so severely criticized for exercising poor judgment in the past, the bishops apparently wanted to avoid having to make any judgments in these cases. And he too, in his issue, in his article, mentions this issue or similar points as proportionality. And Coughlin, at page 990 of his Boston College Law Review article, makes a similar point. Okay, returning to the Dallas Charter, we're going to make a couple of comments about the Charter before going on to the norms. One thing that you'll see in the Charter is that this is the one strike policy, and it says there's one strike, meaning one event, and then the person is removed from the clerical state. But what triggers that? How certain do we have to be? And what the Dallas Charter says is, if the event, the crime, the abuse is, quote, established after an appropriate process. Well, what does this mean, established after an appropriate process? This should raise a number of questions, or maybe it doesn't immediately, but if you turned off the video and just thought about this for 2 or 3 minutes, several questions should come to you. One, just a very basic question, is what's an appropriate process? And one of the things we've talked about already, and we'll talk more about it, is one of the choices that exists on the part of the ordinary, but also sometimes he's going to, with this type of case, would have to have the okay of the Congregation for the Doctrine of the Faith. Are we talking about a judicial process or an administrative procedure? Which is the one that establishes that this incident of sexual abuse has taken place? As we've said in SST Article 21, the judicial process is presumed. We're told that the judicial process is presumed, but nonetheless, the bishop can ask to do the administrative procedure instead. Why does this matter? We've discussed why it matters in kind of broad strokes. Essentially, when we talk judicial process, that's more protective of the rights of the accused. When we talk administrative procedure, that means that it's a faster, easier procedure, going to move more quickly. Let's talk in just a bit more detail. One thing is that the advocate's role is clearer in the judicial process. In fact, if there's a judicial process, there must be an advocate. The accused must have an advocate. If there's an administrative procedure, it's not so clear. The code does not require it expressly. It does speak of, it does speak of the accused having a right to respond, but it does not, in the administrative procedure, but does not talk about the right to counsel. So this is going to be one big difference. Is it's entirely clear in the judicial process you have a right to counsel, a right to an advocate, and that's not so clear in the administrative procedure. Also, even if you assume you're going to have an advocate in the administrative procedure, there are just a lot more stages in the process, in the judicial process, where your advocate can help you. That is, there are going to be several stages where evidence is presented, and your advocate can present evidence for you, but he also can challenge the evidence on the other side, and he can suggest questions to be asked to certain witnesses. You're going to have much less of that with the administrative procedure. Probably you'd be able to introduce some evidence, and you'd be able to give your opinion on the evidence, and possibly through an advocate, but you're not going to have as much involvement in the whole process as it goes along as you would with the judicial process. Also, this issue comes up, I think, of a possible, what some people might call a conflict of interest. With the administrative procedure, remember, it's the ordinary who, before you get to one or the other of these options. There first has been an investigation. Well, it's been the ordinary who has initiated that investigation. Now, if you have these two choices for a process or procedure, if you have a process, it's going to be a judge who, or a panel of judges who runs that process. Whereas if it's an administrative procedure, it's going to be the ordinary himself. And when we get to the norms, one of the Dallas norms says that a lawyer will be provided to the accused if necessary. That's all it says, is if necessary. Well, who decides if it's necessary? Pretty clear it's going to be the ordinary. And when we talk about the kind of the right of the accused to be informed of the accusation early on during the investigation, during the prior investigation, the Congregation for the Doctrine of the Faith has said that normally the accused should be informed of the accusation against him. How is that decided? CDF says, we defer to the prudence of the bishop. Well, the bishop is the ordinary, so you've got the bishop maybe wearing several hats here. He's initiated the investigation. He's really at the head of the administrative procedure. He's deciding whether you need a lawyer, and he's also deciding other issues that may affect you. It may just be too much of a burden for one person. In the judicial process, you're going to have these roles probably more separate. So I think that would be maybe our summary of the difference between administrative versus judicial. Okay, our next issue, we're still in the charter, but a lot of the same issues occur in the charter and in the norms. And this is an issue that Dulles raises. This is mentioned in Article 5 of the charter, and it's the issue of the presumption of innocence. The idea that you don't have to prove your innocence. You're assumed to be innocent. It's the prosecutor, the promoter of justice, or the ordinary who has to show that you're guilty. You don't have to prove your innocence. You're assumed to be innocent unless there's enough evidence to establish that you're guilty. And Dulles raises this issue of are we really honoring the presumption of innocence in practice? And what he really dislikes is this practice of when a priest has been removed from his position because of an accusation, the diocese sometimes will issue a press statement or press release or speak to the press. And what Dulles says about that, and again, this is Dulles writing in 2004, when dioceses routinely announce that accused priests have been removed from public ministry because of a credible accusation of sexual abuse of a minor, such priests are, in effect, branded as guilty. An accusation is deemed credible unless it is manifestly groundless. That last point is important too. First, he's saying there's just been an accusation, and it seems like we're treating the cleric as already convicted. But he's also saying that once these accusations come in, they usually are considered credible. Unless it's they're what he calls manifestly groundless. They simply couldn't have occurred because the cleric wasn't in the same place, or the accuser is clearly unbalanced, or something along those lines. That aside from those situations, the accusation usually is considered credible. I think a lot of people would agree with that. I think that so another way to say that would be the bar for considering an accusation credible is not that high. Okay. Another issue that comes up in the charter, but we're going to talk about it more in connection with the norms, is that the accused is encouraged to retain both a canon lawyer and a civil lawyer. Well, this sounds pretty good. This is, as we said, the charter does recognize rights of the accused. Not a major theme, but it's there. But we have some questions that are unanswered here that we'll delve into a little bit more. One is, if you're entitled to a lawyer, at what stage can you have that lawyer? There's the investigation, there's a stage of what we're going to call precautionary measures, then there's the decision between either a judicial process or administrative procedure. Do you have a right to counsel at all those stages or only some of them? And then another important issue, as you know, who pays? It's one thing to say we encourage you to retain counsel, but who's actually going to pay? Okay, let's get into the norms. Let's get into the Dallas Essential Norms. As we say, these are particular law in the U.S., but your own diocese will have its own version of the norms. Here are some of the rights of the accused that are recognized in the Dallas Essential Norms. So keep in mind, again, when we talk about the norms, we're talking about someone who really has legal force. The charter is more what we would usually call hortatory. It's having overall goals and exhortations about protection of children, etc. But the norms are really more concrete, and the norms are really the thing with the legal force. But even more important to you would be your own diocese's version of the norms. Okay, so we have a list in Norm 6, a list of the rights of the accused. And here they are. One is the presumption of innocence. We talked about that. Another is listed as the investigation will be conducted promptly and objectively. Next one, right to civil counsel. Next one, right to canonical counsel. Next one, prompt notification, that is notification of the result. Okay, so pretty much those five rights are what are listed in Norm 6. So let's talk about let's put it this way. That might sound like a good start. Are there any other rights you can think of that might be important that are not listed there? And let me suggest a couple. What about the right to be informed of the accusation? We talked about that a little bit ago. Now this document is on our syllabus. It's a CDF circular letter from 2011. I think it's on your assignment sheet for the opinion letter too. And that document says that the accused should be informed of accusations before a case is referred to CDF unless there are serious contrary indications. And that's the one that goes on to say the prudence of the bishop will determine what information will be communicated to the accused in the course of the preliminary investigation. That you might or might not be comfortable with that. Again, in a sense, the bishop is being placed on top of the whole process, saying, well, he's going to judge wisely what information the accused needs. But if he's going to be running the administrative procedure, he's kind of a party to it as well. So again, it may look like more mixing of the roles than you're comfortable with, or again, you may be in the camp of, hey, we need to move these cases along. We're going to have to get the best men we can for the job of bishop and ordinary, and trust them to be fair, even if they are filling multiple roles. Okay, so why is CDF talking about what happens here? Remember, this crime now, the crime of abuse of a minor by a cleric, now is reserved to the CDF. But what usually happens there's so many of these cases now, that the diocese does the initial investigation. That's the prior investigation under Canon 1717. And they see, is there reason to believe that a abuse of a minor has taken place? If the answer is yes, then they inform CDF, and CDF tells them how to proceed. That's why we're having an interchange between the diocese and the CDF. So, okay, one right we might want to have, or want to have more definition or more certainty of, is the right to be informed of the accusations. Also, the right to know the accuser. This right seems to be more secure in the Eastern Code than it is in the Latin Code. And many would call it really a very fundamental right, but it's not specified in any of the documents we're dealing with. The right to know the accuser, it's not mentioned in the Code, it's not mentioned in SST, it's not mentioned in the Dallas Charter or norms. Also, the right to be heard in the investigation. This is interesting because the Dallas norms say that, we just said it, that you're encouraged to have a lawyer. It's not always that clear whether the lawyer could really help you that much, because it's not totally clear that you have a right to be heard in the investigation. And again, we're talking about the initial preliminary investigation under Canon 1717. It's not the CDF in this 2011 circular letter does say yes, the accused should be able to respond at least to the findings of the investigation. But that circular letter doesn't say anything about the right to counsel. So here we are. I want to go through the different phases of the trial and see where we stand with the right to counsel. Now, remember, in Essential Norm 6, it says that you have a right to both civil and canonical counsel, but now it's talking about the investigation. But as we say, if you don't have a right to respond, does that lawyer do you much good? Yes, he can advise you, but he's almost advising you for the future, because you may not have as many rights to respond during the actual process. So let me tell you where you are with the right to counsel at the different stages. Okay, I hope you can read this. The right to counsel. Now, I've got in red brackets there Alessandro 20. This is from a book, a practicum that was just done about 5 years ago at the in Washington. Penal and disciplinary situations involving priests and deacons, what can be done and how, a practicum on the application of canon law. And the editor, it's hard to read, but the editor is John Alessandro. And this was in March and April of 2014. Oh, I'm sorry, this was in Florida, not Washington. Anyway, so what I'm taking this from is Alessandro's summary of that practicum. We've got really three stages, because the bottom two, they're alternatives. During the prior investigation, Canon 1717, do you have a right to counsel? The Code and SST say nothing. Now, the essential norm for the U.S., number 6, says yes, you do have a right to counsel, but I put ... but, because that norm doesn't say whether you have a right to respond or to speak or to give your point of view during the prior investigation. So my question is the right illusory? Is it somewhat illusory? Just a question. Okay. Then after the investigation's complete and I'll put the card back up in a minute, but when the investigation's complete, if the diocese decides, the ordinary decides, yes, we're going to refer this to CDF, we have reason to believe that this crime has occurred, then what the universal law says is that sometime while the process is ongoing, certain precautionary measures can be put into place. And these precautionary measures are withdrawal from exercising ministry, withdrawal from office, imposition of residence, or prohibition on residence in a place, and even prohibition on public participation in the Eucharist. So these are things that universal law says can be imposed during a penal process while the process is ongoing. So interesting. They can be imposed, and this is Canon 1722, very important canon, even without a finding of guilt. This is while the process is ongoing. I think it's understandable why we've got these procedures. If there's real reason to believe that this person has been endangering children, we may not be able to wait for the resolution of the process. What's interesting, though, with the U.S. norms is that they say these measures, these precautionary measures under 1722, they must be imposed. Not an option for the bishop or the ordinary, but they must be imposed. So, question arises, do you have a right to be heard before these precautionary measures are imposed on you? So do you have a right to be heard in the preliminary investigation? Not at all clear under the code, not at all clear under SST. Essential Norm 6 for the US seems to say yes. What about, do you have a right to be heard before these precautionary measures are placed on you? No clear right. No clear right, I don't think, in the code under SST, and certainly not under the U.S. norms, because the norms say these have to be imposed if the matter's being referred to CDF. So, so no right there. Again, up to you whether you think that's a key omission or not. Okay, and then we get to our last two. Now, the last two are options. You're either going to have the judicial process or the administrative procedure. Do you have a right to counsel? If you're in a judicial process, yes, explicitly you must have counsel. And the canon references are 1481 and 1723. If you have only an administrative procedure, though, do you have a right to counsel? The Alessandro book says it's implicit but not explicit, and then it references Canon 1720. So again, not that clear of a right. The reason Alessandro says, this Alessandro book says that it's implicit is because 1720 speaks of a right to respond. But again, it does not speak of a right to counsel. So this, again, may be an issue that concerns you as you're thinking about possible reform of penal law. How come the code, SST, and the essential norms aren't all on the same page on certain things, like, say, the right to counsel in the prior investigation, where the U.S. norms seem to recognize it, but the other two don't. And then in the next one, the precautionary measures, those are optional under the universal law, the code, and SST, but they're mandatory under the essential norms. So again, just some things to think about. You're only looking for really three issues that really matter to you, that you want to write about in your discussion of possible penal reform. Okay, Norm 8. This is a key norm. We're still in the essential norms, and Norm 8 is what corresponds to the Charter's one-strike policy. And it says that when even a single act of sexual abuse by a priest or deacon is admitted or is established after an appropriate process in accordance with canon law, then the cleric is to be removed permanently from ministry. So we've mostly already discussed the one-strike policy. I just want to make 2 points about the Dulles article. Now, Dulles makes two points. I think most of the concerns that Dulles expresses, many of them are still live concerns today, and that's why we're reading the article, because I think it holds up pretty well. However, Dulles complains about a vague definition of sexual abuse. Now, in the first version of the norms in 2002, there was a vague definition, and that was later removed. So I wouldn't I wouldn't be too concerned about Dulles's concern. It's just one of his concerns, but I wouldn't be as concerned about that as we might have been early on, 2002 to 2004, because that has been amended and has been made more specific. And what we what we're looking at now, the way it's usually defined, is an external violation of the sixth commandment. So that's what we're usually going to consider a violation of the norms. Or also pornography. We mentioned when we talked about specific delicts that now pornography has been added if the images are of people under 14 years of age. But then Dulles also complains about the possibility, he's talking about proportionality, and he complains about the possibility of someone being removed simply for making a stray remark or a joke. Again, I don't think this is as much. There was a very broad definition that many people considered problematic. That has been made more specific. So this threat of being removed from ministry for telling a joke, I don't think is a live concern the way it was with the original norms. So those would be things that would not necessarily be ones to focus on as you're describing the reform of penal law, because those were very good points, but they were such good points that they were addressed very early on. Okay. And I think these remaining issues we've talked about. Also, this is all in 8A of the essential norms. If the case is time barred, the bishop may apply to CDF for a derogation from prescription. And the norm says that grave reasons are required. Again, this is another controversial issue. We've already seen the prescriptive period extended from 5 years to 10 years to 20 years, and yet we have this provision now that says even now that we're at a 20-year period, we still are going to let that period be lifted and let cases that go back even more than 20 years be prosecuted. Do you agree with that, or do you think that's going back too far? Norm 8A says that the diocese will supply a canon lawyer when necessary. Again, we've talked about who probably is going to make the judgment when necessary. Hint, probably will not be you. But also, what's interesting is in the Dallas Charter, you were encouraged to hire both a canon lawyer and a civil lawyer, but Norm 8A says the diocese will supply you a canon lawyer when necessary. It doesn't say anything about supplying you a civil lawyer. Again, is that okay with you, or is that a big oversight? Dulles, in his article, he really he's very concerned about the rights of priests and the support of priests. For instance, here, are they going to be able to pay their legal bills? And here's a quotation from his article. The essential norms say nothing about the support of priests who have been removed from ministry, and as a result, some bishops seem to be failing to give decent remuneration required by Canons 281 and 1350. Accused priests are, in many cases, very inadequately supported by their dioceses, even in cases where they have not been found guilty of any offense. In effect, such priests are forced into secular employment without being accorded due process of law. Okay, so this question of the support of priests I think it's a very important one as well. It's somewhat external to the norms, but certainly very important if we're considering the life of clergy. You can see why a diocese may not want to support an accused cleric. Look, I don't feel that I can assign him, so why should I be paying him? That's what Cardinal Dulles is concerned about. Okay, I think I'll leave the rest of the norms to your own reading. Norm 13 says that if an accusation has been shown to be unfounded, the good name of the person will be restored. That sounds good. I don't know of too many instances where it's actually happened. And also, consider that language. When an accusation has been shown to be unfounded, then we will restore the good name of the person. That sounds to me, or I'm at least going to say it raises the question. It sounds like the burden may be being shifted to the accused. If I have to show that the accusation is unfounded, where's the presumption of innocence? Aren't you placing it on me to clear my name rather than on the prosecutor to show that I've committed the crime? Okay, so much for the Dallas Charter and norms. Again, feel free to ask questions and we'll address them if we can on Moodle or email. And if it makes more sense, we'll discuss them on Zoom. I really think you should read this article that's assigned about the Irish priest, this by Sarah MacDonald, Guilty Until Proven Innocent. It just kind of tells you one of the horror stories of accused clergy. And it's by no means the only one. You hear of these stories in the U.S. as well. This was an anonymous complaint, and that's partly what this article is about, is anonymous complaints. But it actually, in this article, sounds like what really alarmed the priest was not so much what the state did to him, but how little concern the leaders of the church showed him. Though he does mention one bishop who was quite good to him. I think it's his own bishop who stood by him. So that's a bright spot in a pretty dark story. His lawyer, a man named Robert Dorr, he's represented at least two priests in these types of situations, and he says he's really concerned about priests being hung out to dry here. What's really alarming is that it seems like a very unbalanced person made this accusation against the priest and made it anonymously. And under the rules in place, it should not have been referred to the police or to the National Review Board because it was anonymous. But nonetheless, the diocese did refer it to the police and the review board. And then eventually, what this priest decided to do to clear his name is he sued the accuser. Somebody convinced him, said, "You're never going to get out from under this until you sue the accuser." He did so. The accuser admitted that the story was false. The man's name was cleared. He was returned to ministry. But while the case was going on, he found out that the diocese knew all along that this kind of unbalanced accuser had stalked him, had stalked the priest. This guy admitted he had stalked this priest, and the diocesan personnel never told him about it. So really, really a sad story. Now this priest, I think he's trying to help other priests in this situation. As bad as this story is, he's kind of one of the lucky ones because he was able to clear his name, but he's concerned about others who are falsely accused. Okay, well that brings us. Sorry that this final lesson 6 lecture was longer than I wanted it to be, but this completes lesson 6. So stay tuned for a new syllabus and a new lesson in a couple of days. Thank you very much.